Good morning, everybody. How are you today? Thank you for joining me. I am the Squeegee of Justice, and this is Trial TV Live. We are going to be taking a look at Karen Reed's hearings the last couple of weeks, while we are taking a break, if you will, from Monica Cementili. Well, they're dark this week, so we are covering some other trials. One of them is Karen Reed. So today we are going to look back at the one from February 18th and then February 25th. So in case you missed those, you're in the right place. We will cover those and we'll try and answer your questions. And but first of all, let's see who is with us today. Therapist you know, coming off your birthday weekend. Hello to you. Fala, good morning. Regina Crawford, Mathis Grease, good morning to you too. Thank you for joining us. Baka, good to see you. Thank you. And Fala, how is your foot? Lily Wayne, hello to you. Good morning. Krista Limited Edition, good morning to you. Only Fan, hello, hello. Cajun Bayou Queen, hello to you. Krista gets a tackle hug from Fala. Hugs to all. I hope your ankle foot is doing better. All right, so let us get into Karen Reed. So for those that don't remember, she had a trial last May and June. It came back as a hung jury. And initially, Miss Reed is accused of hitting her Boston police officer boyfriend, John O'Keefe, with her SUV in February of 2022 in Canton, Massachusetts, which is a suburb of Boston. And she is accused of leaving him to die in the cold. But as you may know or remember or not know, they were out drinking. They connected with some other friends of John, and they went back to one of their friends' houses, and he just happened to be a retired Boston police officer. And there were, maybe 10 people in the house, and nobody saw or heard anything, but everybody seems to think that Karen did this, even though there's a lot of evidence that points that she did not do this. So we shall see where these hearings take us. Let's get into it. Let's see here. Let me just get myself set up here. All right, so this first hearing is from February 18th. This is addressing the defense motions to block the retrial on certain charges, citing double jeopardy concerns. So that's this one.
Now open. Please see.
iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video. Which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, He went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan, and it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years, and this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement, we met right back there in that room, we said that you could videotape the download of the videos, you don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford, it was Colleen Crawford. She went and called Mr. Brennan according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. If you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that in fact it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later. And after, they filed a motion making representations that weren't accurate. I no longer had the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after, because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process, and I wanted to ask firsthand anybody that was there about the process, because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file, because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR, DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today is, it'll be done by the end of the week.
You want to make, I'd be heard briefly.
Yes.
Very, very briefly.
Take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that. It's pretty immaterial what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. And we're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want the...
October 24th, did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, and I'm no expert, my understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. What's the metadata associated with all those things? It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that, but the issue is going to become that when we drag and click these videos, and if there is no metadata or logs or what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system, so if there's something they want, then we'll copy it for them.
Okay. Thank you very much. All right, Mr. Yanetti, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that.
Right.
I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel? Thank you, Your Honor.
Okay, the next one's paper.
May I be heard briefly?
Yes.
May I be heard briefly?
Yes. Yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay.
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right, and I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney, and that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case. That there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. In the discovery in this case, was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage, and I am worried, and I have good reason to be worried, about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses, and this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so, while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again, it does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures, because this trial is going to happen, and these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse, and that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney, so I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Ms. Yanetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right. We'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and or Metro Court. Relatively straightforward, but I'll hear you. Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay. There's no objection to this, is there?
No, Your Honor.
Of course, I'll provide the defense a copy if they want.
Yes. All right, so this is allowed. So the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today, and today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us, and I would ask that the court take no action on this motion until we've had a chance to view them, and we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first, or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has a wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses, and that's what we're asking the court to reconsider. It is our position, Judge, that part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data which revealed that that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure, from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, you know, we question what was done behind the scenes to, you know, arrive at that conclusion as well. And, you know, I also, you know, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed, so I take responsibility for everything that's in there. But, you know, we also make the point that with regard to, you know, Trooper Proctor, it appears as though there was, you know, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well. You know, if we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but, you know, this is a I won't say unique trial, but it's a rare trial that, you know, is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with, and to the extent that we turn over this impeachment material and the Commonwealth uses it, you know, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward on cross-examination. So switching to the Commonwealth's motion for sanctions.
You know what, let's wait. When I said both, I thought you made 2 points that you made about the 2 points.
Understood, understood.
All right, so, Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to Sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense. Because it's in my possession, custody, and control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos, it's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it will be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. The only thing I would point out, Your Honor, is that with regard to the report of Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with...
I'm sorry, before you do, so you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or?
Yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There are certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct. Nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARRCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it. A factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense, so we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland and Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the Department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024. Please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCCA, and we'll discuss that in more detail when we get to the ARCCA motion, and expert discovery. We have provided, there is a difference between ARCCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCCA, and again, I'll delve into that when we talk about ARCCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week. And I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're over 500 at this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCCA motion, Commonwealth's motion to exclude employees of ARCCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARRCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARRCA, and it was represented these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed, and over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARRCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARRCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi Alan, subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. I'll also attach my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So, I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
All right, I'm going to take a recess before the response.
Court, all rise, please.
「
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
That does not. It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh, great, thank you.
Is there any way we should use this for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
May I have just a moment?
Yes. Thank you.
Your Honor, we'll accommodate the 25th, one way or the other.
All right. So we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
Of MSP report.
All right, let us run through what just happened there. So this was from February 18th, and it starts out with the defense talking about the footage of the Sally port, which was on an iCloud, but now it's on a retired employee's hard drive. So they want the metadata and the log files. So they just want an audit trail. The Commonwealth has the data, and the defense wants it. Seems like a reasonable request. The detective file is yet another name of where the data is being stored. So then the Commonwealth gets up and says they invited the defense to download the information. It's a retired sergeant was the one to download the video. It's on a DVR. You would download, so it was on a DVR, he would download it, then he would save it to his detective file because he was a detective. It's simply a matter of click and drag to a hard drive and provide a copy to the defense. Doesn't know if the files now have metadata. All files have metadata, no matter what they are. They always have metadata. He wants to meet their responsibilities and wants to give it to the defense. It seems like when I extend courtesies, it becomes complicated. It can be done in one day. The defense comes back. Well, he's more concerned about it. So Alan Jackson's like, well, I'm more concerned about Mr. Brennan's representation than the actual information. So the Commonwealth didn't talk about the metadata. So we got video before trial, we got video during trial, and we got video after trial. So where are these dribs and drabs coming from? Why don't they just give us the whole thing? So October 24th is just the video file, doesn't contain metadata. I don't understand that. All you have to do is hit Command I. All you got to do is just look at file, hit Command I, and there's your metadata. It's impossible to not have. I just don't understand what Mr. Jackson was talking about there, because everything has metadata. Apps have metadata. I'm just doing everything has metadata. So I'm not sure why he was saying, I didn't quite follow that. It should have an executable file, an exe. It should have a video player, and then the metadata. So he's saying that they should provide like QuickTime or whatever their default. That should just be on the. I don't know. I don't think that's up to to anybody to provide. That should be on your own. Should be on your own system, but that's what Mr. Jackson is asking for. The executable file, which would be the video file itself, but then he's also asking for a video player and the metadata. Metadata exists; it's there. Aren't exe files Photoshop files? Well, exe is like that's PC, but yeah, if it's a Photoshop file, it says .psd. If it's InDesign file, it has its own. They have their own dot whatever. So he's asking for an executable file, which to me, I'm trying to find a video file that I have, which would generally just be would be QuickTime for me. That's my default. Trying to find a, let's see, intro. Okay, so here's an MP4. So all I do is hit Command I, which is info, and there's my metadata. This was created January 4th. It was modified January 4th. It has the dimensions. It has codecs, color profile, duration, audio channels. It tells me what it is. I can open it up in QuickTime. So I don't, anything can, you just hit Command I on a Mac. I'm not sure what it is on a PC, but info, just get info, and there's your metadata. Tells you what kind it is, what size it is, where it's backed up, when it was created, when it was modified, the name. You can open it with, tells you what to open it with. This is Premiere, this is a Mogert, this is a Premiere. Let me go back to this. Yeah, open it with QuickTime Player. That's my default. You could open it up with. I didn't quite follow Mr. Jackson's logic there, but anyway. Let's see. So then the Commonwealth comes back. There's no attempt to hide something. They're asking for something I don't think we can accommodate. Our duty is to provide the video, but what more can we do other than invite them to the Canton Police Department and video the process? So Ken, you've had really that they can strip the metadata? You've had lawyers take discovery and put it on certain web hosting services that strip metadata? Yeah, Krista, metadata is hugely relevant in this case. I didn't know that was even possible. Ken, I didn't even realize that was possible. Yeah, I've never run across that. I've never had anybody strip metadata from me. So I never run across that before. Doesn't surprise me, I guess, but okay, let's continue on. Okay, so the next was the motion for pro hoc vici. So this was Mr. Betterow. This was Mark Betterow's wanting to be a part of Karen's defense team. So Judge Cannone Bev says, Judge, so she's likely to allow, but needs more detailed affidavit. Well, we know how that turned out. But anyway, let's move on. Commonwealth says not in opposition, but has some thoughts. Defense has the right to choose any counsel. Mr. Betterow is also an attorney for Mr. Kearney. There's a history between Karen and Aiden, Ms. Reed and Mr. Kearney. Over a dozen indictments on Mr. Kearney, and Betterow is representing him. Betterow will be serving two masters, one from Karen, one from Kearney. It will be difficult, and this kind of made me chuckle. It will be a difficult task to handle. So he's basically saying he doesn't trust Mr. Betterow can actually handle this. And I have reason to be concerned. While I do not object, the court should have some caution and concern about the nature and whether protective information was shared and that it doesn't get shared in the future. Witnesses should be able to walk into the courtroom without fear of bullying. So he's basically, Mr. Kearney's, in court right now because he's intimidated some witnesses, So that's where that ends. Judge says, I'll have to consider everything that was just said. So at first she said she was going to just, I'll allow it, but I need a more detailed affidavit. But now she's going to have to consider everything that was just said. Okay, motion. The next motion was from December 5th to amend audio of Gretchen Voss. The Commonwealth wants the audio to be transcribed. They sent it to a transcriber, but told them not to listen to it. He wants to make a copy first. I'm not quite sure how they're going to transcribe it if they don't listen to it, but defense didn't have an objection to that. The next motion was for a court order for the defense to have access to independent testing of Alexis. Brennan gave this drive to the defense in the spirit of cooperation. No action was taken, so I guess that's gonna happen. The next was motion the defense to consider reciprocal discovery order. They would like the ability to impeach Commonwealth witnesses. The effectiveness of cross is to surprise a witness. Seems like Trooper Proctor was watching the trial and notes Proctor's commenting on Jackson's closing. If we turn this over, it blunts our ability to be effective. Witness could potentially alter their testimony. I thought they have to turn over all discovery. I'm surprised that they're saying that, but the Commonwealth said the court shouldn't enforce this. The trial by ambush is simply that. The rule requires them to turn over discovery. A witness has the right to look at evidence before testifying. Any emails he gets from random people, he turns over to the defense. Yeah, I didn't quite get that argument from Yanetti. Why wouldn't you turn over? I mean, I understand that you want to ambush the witnesses, but how can you not turn over your evidence? Defense came back up. Yanetti came back up and said Jennifer McCabe report wasn't provided until after she testified in the first trial. Commonwealth comes back. I've been on the side of late discovery and will try to give more discovery than required. The next was motion for defense to compel discovery. So the defense comes up. All chain of custody logs came into possession of video. This was Miss Little. 3 separate video productions provided, one before the trial, one during the trial, and one after the trial. The only report we've received is from the July 2024, this IT person's review of the video. Then she brings in Sandra Birchmore and Lank, Albert, Clark, Fanning, Tolley, Morrissey, among others. Those were the ones I recognize, the names I recognize. That's just amazing. 1, 2, 3, 4, 5, 6 people that are involved in both. All are material and relevant witnesses, and the parallels in these cases couldn't be more clear. Failure to investigate law enforcement who should have been a suspect. That's huge. She wants communications in the Birchmore case to be handed over. She wants unredacted documents because the one she got is so redacted they couldn't even make sense of it. The reports go directly to the credibility of law enforcement. Absolutely. There's tens of thousands of texts between Farwell and Birchmore, and they're very, very damning. I haven't read them, but Ms. Little said they're pretty damning. Then the fifth motion within this section said documents of internal affairs investigation of Trooper Proctor. That would be good to have. Number 6 and 7, there were no objections. Number 8 and 9 were communications between law enforcement and the DA office. And number 10, there was no objection. So the Commonwealth comes back and says it's important to represent facts accurately. So for number 1, the Commonwealth won't make up logs that don't exist. If these existed, they would get them. Ongoing federal investigation, the defense would like to parasite onto. They throw out words for the audience to our right, basically, all the news media. It's easy to throw out names and malign their names. So they're talking about Morrissey and Lank and Clark and Albert, He doesn't know about a report from Trooper Garino about nothing to see here. There's no good faith discovery that there's anything in this case that fits this case. But they're the same people that investigated both cases. There has to be parallels. I mean, how can you can make that inference very, very quickly. That's not a leap of a large leap to make, Number 4, troopers work on many cases, and that certainly has a public appeal, meaning the Birchmore case, to it. But what does it have to do with this case? It has everything to do with this case because it's the same people. It's the same prosecutors. It's the same DA. It's the same troopers it's the same investigators. That was a weak argument, Mr. Brennan. Sorry. Number 8, there is a difference between ARRCA and experts' discovery. He provided the entire case file for their experts. The next motion for the Commonwealth to exclude ARRCA experts. Yeah, they're scared. They're afraid of the ARRCA because those guys definitely will blow up this case. I just hope this isn't going to be like the Menendez brothers, where the first trial they heard everything, and then the second trial they heard nothing. And of course, when you hear nothing, it's going to be a different outcome. So let's see. The Commonwealth went first. It's my purpose not to deprive the defense of an expert. There has been a full discourse when calling an expert. Since there's been a voir dire and a trial, they think that that's enough. Now, Brennan is asking for full discovery. So let's see. He talks about June 10th, 2024. These experts were hired by the government and they could not prep us for trial. Could not prep us. He makes a point of saying that. There was a couple other things. Called the feds and encouraged them to provide full discovery so ARRCA could testify. He filed a Tooley letter and got a response that was no response. He talks about this outline. He says it's not dated. And he was really snarky. He's like, here's this outline from a fair-minded and objective witness. He says they're not saying they're not qualified, but it shows bias. And specifically, they were talking about how nighttime pedestrian accidents occur more often. He says, if you don't want me to say that, it's fine. And then that was in the outline. That was the notes. And then Brennan's like, shh, don't say that. There were a couple other things that he said that to him show that it was bias. Then the bill for $23,923, I believe it was, to the defense. I think that's what sent Bev over the top. Doesn't know any of this. Sometimes experts pick sides. He says, I've been around feds long enough. I just care that it's balanced. I just care that it's unfair, unbalanced, and hidden. And then the judge says, the Commonwealth just provided me with info that caused me grave concerns. This has profound effects on the defense, and I am suspending proceedings for today. So that's that. We will pick up on day the second day, basically February 25th. But what are you guys saying? Hey, Joanne, good to see you. I wish Auntie Bev wasn't hearing this case. A new judge would be beneficial to all. Couldn't agree with you more. Hey, Florida PI Sam, thank you for joining us. I hope they teach this case in law school in a how not to practice trial advocacy class. Legal Minded Friends, Karen Cole, was in notes or Brennan added himself? That was Brennan adding that. He was adding some snark, so that was him. Yeah, the note was, if you don't want me to say that, it's fine. And then he's like, shh, don't say that. So that was definitely him. Let's see, what are you guys talking about? Ken Rosenberg says, but the lawyer shared with a public link and that overwrote all the meaningful data. Curville says, key factor for me also was evidence bag sent to lab labeled debris from clothing, jeans, shoes, t-shirt, sweatshirt. Baca says, I think you probably mean to say the same, and how Bev has not been removed from the bench is beyond me. Florida PI Sam, been doing a little looking into Massachusetts State Police. They have issues. Yeah, the two cases that are on our radar, they have incredible issues for sure. For sure. All right, let's move on to the next hearing, which was from February 25th. Let me just change this. So this next one is going to be February 25th. Let that get caught up. So as you heard them at the end, they were trying to figure out what was the best time, the 25th or 26th, and they ended up on the 25th. All right. All right, so this one that we're going to hear is from February 25th. So let's see. All right, so this one is from February 25th, 2025. Okay.
That's for me.
That's for you.
You are unmuted.
Please be seated. 22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good
Good
morning.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Your Honor. David Yanetti for Karen Reed.
Good morning, Mr. Yanetti. Good morning, Ms. Reed. All right, so last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCCA witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Mr. Yanetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Alessi.
You're welcome.
Thank you.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor. May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor, and because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so you were addressing this in chronological order as well, right? Yes. So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes, your number 8.
I will tell you exact pages that I'm going to refer to. And Your Honor, get to the... This is tab 8 in the notebook. And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to suspend my brief or keep going?
No, you can keep going, and we'll stop so I can read whatever I think I need to read at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go right ahead, Mr. Alessi.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts. But I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARRCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARRCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARRCA. They had the opportunity to contact ARRCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know. But I understand the facts to be that the Commonwealth didn't make contact with the ARRCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARRCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARRCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yanetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was
Was the federal protective order that was referenced by Mr. Yanetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, I wanted to say, I'm going to answer it directly. What Mr. Yanetti articulated is the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, important answer, I understand. But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yanetti is not copied on the email, and my understanding is Mr. Yanetti is not knowledgeable about these communications. So the email reads, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly inchoate at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is, I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCCA's willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yanetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yanetti never mentioned the ARCCA experts in his opening?
I did not review the openings. I reviewed only, for the non-evidentiary transcripts I reviewed, was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yanetti did not even mention the ARCCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Right.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening, so that pause continued through the opening. That, to me, is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire. And that the ARCCA witnesses were going to have to come up from Pennsylvania and they were going to need to sit for a voir dire. I will get to the significance of that. But that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5. The court. Now, regarding the 3 experts from ARCCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yanetti, Your Honor, we've provided everything that we know. We mentioned to this court at Sidebar these experts did not arise from us finding them. The court, I understand that. Mr. Yanetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yanetti said. There's more to that statement. There's an elaboration of it that is important. The court, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question...
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes. And I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them. But that was what Your Honor was concluding from what was stated. So what did Mr. Yanetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes 2 people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yanetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides had. And I know the immediate response might be there, it might be at this point, wait a minute. You haven't had time to interview, etc., etc. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yanetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yanetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's, Mr. Yanetti says, that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3. And it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right, I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARRCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice, and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages. Not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask, and as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email. But it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yanetti on this email. And Your Honor, because I've said it so many times, Mr. Yanetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, that the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face, and one of it is you can always tell what goes along with the email. So this is attachment Wolf-Qualls document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I'm well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony, in that very point, was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course it has the D&T of Dr. Wolf, his experience in testifying in court, etc., etc. I will indicate, Your Honor, that the information in terms of quals, etc., all of that, to me would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARRCA, the frozen in concrete report of ARRCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom, is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the Rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14, and we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, etc., etc. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, etc., etc., and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, etc., etc. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, etc., etc., that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire, that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right, that are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered. We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up? Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility, so there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited. Discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is, again, by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Miss Little? No. That's correct. Mr. Yanetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer, correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now if you could continue on, Your Honor, to, I believe, if I could be so officious and say this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement, to the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct, question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And, Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation. But I do know a fact, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor.
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So, can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding, yes. And you were equally available to both sides in terms of them reaching out, correct? Yes, and I called you ultimately after receiving your report and asked if you join us and testify, correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARRCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf, and I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARRCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings, and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes. I think that's a fair characterization. And reversing that was your accident reconstruction, also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle. So it's important to know, in terms of, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same, and what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, the findings of ARRCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARRCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your prefatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses, and there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARRCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. Right. I'm not speaking with firsthand knowledge on any of this. But I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. These are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because, as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing? Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation. Your Honor, I understand a check was sent to ARRCA on July 25th.
Thank you.
You're welcome. So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, about the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's very important question. But it's an important fact point as well that call was made. So, in terms of the next tab, which I've been alluding to during
so this is the one I said I needed to take a recess to read that.
I was just going to say the same thing.
Right,
this is now that point.
All right, why don't we take a 15-minute recess?
All rise.
You are muted.
May I continue, Your Honor?
Please.
Thank you. So, Your Honor, to blend and quickly summarize what we've gone through, I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We talked about June 10th and statements of counsel. We've talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now, with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCCA as a witness was made 5 times. I counted them, and we'll go through each one and number them. Or deprive the defense of an ARCCA expert in this case. Very important, because from my perspective, what was put in the firing line on February 18th was the ARCCA experts, albeit indirectly. So now we go to page 54. And this is going to be, in some points, a line by line, because the words matter. Line 5, and this is again is Attorney Brennan. Mm-hmm. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup, is all in...
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025. But it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, etc., etc. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCCA. And why do I keep repeating this? Because my conclusion is going to be ARCCA should be unscathed. ARCCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had, for 5 days, the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before. But his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here, there's much more to the story, and I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here, is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information, so they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the ARCCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements, or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So, next, on page 57, line 11, he reads, response, "Hi, Alan. Subsequent to our conversation on Wednesday," this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, I am going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate, and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter, and unfortunately sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARRCA experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, jury requests, and an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. My, that's not a fact, but if that were true, that would be very bad. So
what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll start back up at 2.
Okay.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea, and I'm not rushing you, do you have an idea, because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes. Because I have to get to the law, the 3.3a. I have to.
I'm not rushing you. I just wanted a time frame.
That's my best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal. Believe me.
Okay, so we'll see everybody at 2 o'clock.
You are muted.
All right, we can zoom, but let me just go over what we've heard so far. So this is February 25th, 2025. Judge Cannone says, previously undisclosed relationship between ARRCA and the defense. She heard about these emails. She heard about the emails and the retainer 2 months before they appeared to testify. So Sunday before the proposed script, after trial bill, not just for travel, but for trial prep. Clearly, they expected to be paid, so it made sense for defense to have time to reflect on this new info, so counsel can be prepared to make their comments. So she's talking about why she ended the trial from the 18th. What the Commonwealth said was inconsistent with her memory. She's operating under the assumption that counsel couldn't provide discovery because of federal protective order. Yanetti said at Sidebar that Brennan has the same info I have, and he got it at the same time I did. So she needed time to reflect. So that's why she stopped the hearing the week before, the 18th, and now the 25th they pick up. So Mr. Alessi picks up for the defense. He says, thank you for letting us be heard. He has a notebook he just gave to Mr. Brennan. He also gave it to Judge Bev. He says he understands the moment. He starts with the notebook because it's in chronological order because the facts come from that. The chronology will address many issues and concerns. He uses the words elucidate and illuminate is the goal, not to obfuscate and conflate the issues. He will go through the notebook efficiently. Efficiently for sure, but efficaciously, and efficiently. He's dropping some good words today. So he started putting it together a day and a half ago, and he completed it just this morning. So he starts with the March 20th email from Mr. Jackson to Mr. Wolf. The federal investigation produced the ARRCA report in February 2024. Findings of the report, whether or not the vehicle made contact and John's injuries were a result. The findings were set in cement in February of 2024, and they couldn't be changed. Set in cement. Both parties could contact ARRCA. Only the Commonwealth knows why they didn't contact them. Oh, we know why. Everybody in the room knows why they didn't contact them. The defense surely did contact them. He reads emails from March 20th from Mr. Jackson to Mr. Wolf, along with your retainer as required. So it is required that they pay. So no substantive conversations between the two. Mr. Jackson was seeing if ARRCA was available and willing to testify at this point. Then he reads the June 10th transcript, or he talks about it. The trial started in April. So Mr. Yanetti never mentioned ARRCA in his opening. Never mentioned. In his opening, it said, hey, you're going to hear from ARRCA experts. They're federal. They were hired by the feds. They were, he didn't even say that. Didn't say that at all. That's pretty big because the defense didn't know they would be testifying. The most powerful testimony would come from them, of course. If there was an agreement, we certainly would have added that to the opening. Then he talks about the June 10th transcript of them actually testifying. It was outlined that ARRCA couldn't prep with us before trial. Judge says, so I'm to understand that you're calling 3 witnesses that you've never spoken to before putting them on the stand. That's what she literally said on June 10th. Judge offered remedy by saying that there will be a voir dire. So judge set no limitations on the voir dire. So they could have asked anything. They could have asked any questions. Lally could have asked any questions of the 2 ARRCA experts. Alessi says, we didn't, the defense didn't blend the experts into the report. It was sent to us. It was what was sent to us. Again, cement. It was cemented in stone. There's no compensation. There's no promise. There's no reward. There's no inducement. There's no favoritism. We know the Commonwealth knows how to conduct a comprehensive voir dire. Look at what Mr. Brennan did with Dr. Russell. We know, that took like 2 days. Dr. Wolf was on direct. He says, I do a lot of work on nighttime visibility work. So that was like a big thing that Brennan brought up, Then there was an email from Mr. Wolf to Mr. Jackson. No Yanetti's on this email. This was June 22nd. There was a division of labor. Alessi's talking about the division of labor. They're in the middle of a trial, so no collaboration was going on. Mr. Wolf was the one that put on the outline of qualifications. I will try to work on some direct questions tonight. So that's Wolf that was saying that. He said, I loved your voir dire. I loved your questions. I'll work on some direct questions for you. So this is all Mr. Wolf making this, not Jackson or Yanetti. Then the nighttime visibility work, if you don't want me to say that, that's fine. I remember Brennan brought that up on the 18th, and he's like, shh, that's the one where he said, shh, nothing to see here, or whatever he said. That's where he said, shh. That very point was elicited by Mr. Jackson. There was no hiding that. Judge says I read that as well. Then on June 23rd, again, Mr. Wolf sends an email to Jackson saying, here's my attachment. Here's an attachment of, I think it was like his CV and maybe something else. The invoice, and then Alessi says this invoice came out of the blue. It was sent to Jackson's office in July. And so he's like, so what happened? So Adam Deitch at the state attorney's office, they called him and they asked him, where did this come from? And can we pay this? And will be in violation of anything. And Deitch said, yes, you can pay it. So the judge asked, did you pay it? They said, yes. So the invoice came in July 12th. Jackson's firm communicated to Karen. This invoice came in around July 24th. That's when he sent the communication. And then it was paid the check was sent on the 24th. So literally it was paid like the same day that Jackson sent it over. Let's see. So to summarize, he goes over the timeline. Then he goes, now I will. Of course, Bev cuts him off. You don't have to tell me what you're going to do. Just go ahead and do it. Then he cites Brennan again. Mr. Brennan, I don't wish to deprive the defendant of an expert. He said that 5 times. So Brennan said that 5 times. Then he goes through more of Brennan's argument. When words are used like ambush and duping, those are some fierce words. Brennan says, we have some materials that we got from the government. Alessi says we gave them all discovery. So what they got, they all kind of had access to the same. So Brennan's complaining the week before that he didn't receive, he got ambushed by this email. We now know that is incorrect. This isn't info provided by the defense. The defendant provided an outline of questions for direct. That's blatantly just false. When Brennan said that on the 18th, it wasn't the defendant that provided the outline for questions for direct. It was Mr. Wolf that provided that. Commonwealth is accusing the defense of providing questions. So whether or not they're playing dirty, I don't know. I guess all's fair in love and war, and this is not a walk in the park, clearly. So what are you guys saying? Oh, here, let me just give you a quick little shot of said Super Bowl. Chilling out on her little pad. Yeah, that's a good girl. She loves her little pad. That was provided by therapist so thank you very much for that. Let's see. Fala, you're going somewhere. Where are you going, Fala? Chiseled in stone. Yes, Baca, chiseled in stone. Yeah, Rachel B. Yep, I'm not rushing you, but hurry up. Yep, I'm not rushing you, but hurry up. I'm not rushing you. Yep. Krista, limited edition. Brennan made it seem way shadier than it was. He did. He really did. When I first heard him saying that, I'm like, oh no, but therapist, but was it snowing? Lil Miss says, I'm hoping that you guys will be done with Monica by the 1st and we'll be watching this trial so I can come back. We are not going to cover this trial. We have decided that we're going to cover Lori Daybell. So you're more than welcome, happy to come back with us and watch any trial that we cover, but we will not cover Karen Reed. We are going to cover Lori Daybell. They're pretty much going to be going on at the same time, and we have a court reporter inside Lori Daybell. So we will have somebody actually there. That's pretty much why we're going to not cover Karen Reed. Curvio says Brennan really misinterpreted it. Yeah, well, he spun it. Irish Amy, Paulie's acrobatics were impressive. I'm trying to think, did we post something? I forget. Daybell starts, jury selection starts on the 1st. The 31st, and then they're not sure when it's going to start. It could take a week, it could take a month. They're not quite sure when it's going to start. We're hoping it starts around the 7th or 8th. There will be 23,847 other channels covering Karen Reed. Absolutely. Baca says, much rather watch Lori Daybell. Yep. Brett says the whole nonsense turned out to be the facts that the defense brought out in voir dire. Yeah, the defense was really hiding things there, for sure. Oh, Paulie climbing the tree. Yes. Yes, Paulie climbed the tree yesterday. Yeah, Aaron took a video of that. Yep. Low miss. Oh, Daybell would be good too. I'm torn between which two to watch. I know it was a toss up for us, but then we are going to have a courtroom insider. So we are going to have somebody in the courtroom, and we're going to be talking to them. So that was kind of what pushed us to that side to go with Lori versus Karen. Karen's going to be a good show. I mean, both of those are going to be great trials, but Lori is going to be, Lori Daybell. It's going to be, If Karen was representing herself, then that would make it even that much more difficult. Hey, Aaron C., welcome back. Yeah, that she's pro se, of course. Yeah, courtroom insider. Where? Who? What? That's going to be at Lori Daybell. Lori Daybell. We have a courtroom insider. All right, let's get back to Karen. let's get back. I can do some zooming. So we're caught up. Yeah, it's really funny. We have Monica, female, long trial. We have Karen Reed, female, long trial. We have Lori Daybell, female, long trial. Donna Adelson, female, long trial. Corey Richens, female, long trial. Like this year is just like, right now it just seemed to be like women, long trials, right? We haven't, we just have all these long trials and they're all female. It's really funny. Yes, it will be Joe Schmo. We are hoping that we can connect and do daily call-ins with Joe Schmo. Krista, I have to see Karen Reed to the end. Too much time invested. LV will be on replay. No worries there. We know everybody's got to make a choice. I get it. Everybody makes a choice. We had to make our choice. It was one or the other. We couldn't do both, so we had to make a choice, and we ended up with Lori. Only because we are going to have Joe in the courtroom. He's going to be there. And I'm hoping Gigi, too. Hoping we can talk to Gigi. Just like we talked to Gigi for Zachary Hughes. So, Hellcat, I hadn't thought about that, all the long women trials. Yeah, it's really funny, right? It's just funny how it's, did not want to do that, Chris. It's really funny how it's working out that way. I don't know how and why, but that's just the way it is. Baca already been through Karen Reed trial, don't need a repeat. I know, it's tough. Trust me, it's tough. It is tough. It's a tough choice to make, but we have to make it. So, all right, let's get back to Karen.
We're back in session. May we see it?
All right, Mr. Alessi, why don't you go ahead and continue?
Thank you, Your Honor. May it please the court. I first want to thank Your Honor for the generous amount of time you're according
You need to thank me. Just go right ahead, sir. And take your time, Mr. Alessi. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote the, and it's good to have, if Your Honor can be, having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email.
Yes.
And because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept, because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, etc., etc. So compare that, please, to the quote, purported quote on page 57. 11. Hi, Alan. Subsequent to our conversations, and he's quoting purportedly this email. On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58. Yep. And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try as my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
it probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
Okay. All right. Go right ahead.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And
do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
And I'm understanding Your Honor would like me to pause until you get
Just,
there.
if we can, because I'm looking at a calendar. If you don't, I thought you may have had it. We can move on.
I believe it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Ms. McLaughlin.
And, Your Honor, it was a Thursday.
I'm sorry?
It was a Thursday.
Okay, thank you.
So, also, in big bold letters, at least on the printout, the subject is Karen Reed-ARCCA reciprocal discovery. It's not like it was buried, what was being sent. I mean, this was a lot of things, but it's right there, ARCCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confer with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like this, ARCCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you're... Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah, so that itself is not, I understand it's with the email, but it's not dated separately.
Well, Your Honor, I was going to get to that, but there's context for that.
Hey, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
So what is the date of the, so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one? When was that sent?
The other one was sent the day before on June 22nd.
Okay.
I'm just going to give it the name that the email has. I think it's @wolf_quals document. Okay? So there's two emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says.
Sure.
The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I...
I'm going to actually hold that thought. I just have one other thought about
Yes,
this.
please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
and you're
correct.
saying that this was disclosed prior to the February 18th hearing. But was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
That I
answer-
just wanted to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA. There's another okay, so to speak, with ARCCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, but blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago. 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, etc., etc. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have, I agree. It would have been, and you did. Twice. Next. Reading on the same page 16. He's quoting. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice. In the voir dire and in the direct. It was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, nope, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry. There's another point at the no. Let's go if we could. I don't want to take the lesser significant ones. I want to focus because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARRCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases, I've been around the federal court a bit, I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, and 6 weeks before the trial is starting, the defense affirmatively turns it over. And does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made. Sometimes parties pick sides, agree, blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts. illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion. It's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used to, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARRCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial. And the reason I've got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this and the court staying a break, is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case? Or are you just saying generally you've had this issue in other cases, or do you mean this case?
Other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break, so we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key, so you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I've made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I have to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court, I might have asked for a sidebar and come up and said, Your Honor, my bad. This is that. But that didn't happen. So what did happen? The Commonwealth says, I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that, I think I said, the federal government, it was the defense. February 13th, they sent us the emails in the direct examination outline. I think I said. That was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get them. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just the emails.
I thought it meant everything, but...
I don't understand how that conclusion can be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out.
It's because I received a copy of it.
Pardon me?
Right. I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, and you've got to correct a material and I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this: being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended but that parties could contact ARRCA. Obviously, the Commonwealth is in no position to contact ARRCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them, yet at the same time the Commonwealth for the fourth time has moved to strike our ability to use ARRCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements. 10. Before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got. Because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize Your Honors giving us of that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move rather, hopefully, efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because you're...
Again, you don't have to tell me what you're going to do, Mr. Alessi. Just go ahead and do it.
I'll just go ahead and do it. My apologies. So now let's just turn to Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the notebook. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false, of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. Essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yanetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time to that?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
Right, so I have that entire transcript, like I said. What page are you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with? No, okay, I received it. I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then, Ms. Buchalter, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14, and so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court, move to exclude the witnesses? Mr. Brennan, yes. The court, what do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court, I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right, last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides' discovery. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than waiting. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them is that when you want to exclude it, so I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses, The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days, technically, to turn it over, but it got turned over on the 12th. So then it continues on, is important. The court, if I don't exclude it, would other side be seeking a voir dire? We would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the quals, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when, and so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has, the court is entitled to look at the circumstances and, as the case law says, should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is, unfortunately, a woman attorney was in a bad divorce. She had financial statements, and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she didn't. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yanetti or Mr. Jackson. In sum, Mr. Yanetti's statements on June 10th, all completely accurate. All completely accurate. Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARRCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, etc., etc. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARRCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So, if they can produce the discovery, I'd welcome ARRCA. I want to repeat that.
You don't need to repeat it.
Okay, so my point is, we produced the discovery. Why is there still an issue with ARRCA? These aren't my words. So, I want to cover, before I get to the Sixth Amendment issues, the point that ARRCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARRCA. So I want to touch that base to make sure that either intended or collateral damage, that ARRCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, doesn't correct it, the Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped, and I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the
is that counsel pro hoc vice, or is that not?
I'm going to get to that. The answer is the counsel. I want to be sure of my answer. Yes. Okay. And I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it that says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, etc., and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a revocation of pro hoc vice. There's a difference,
there is
obviously.
A difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done, that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so, the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th, there were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument, I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I've provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say it as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, that Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yanetti, any questions Your Honor has, I would greatly appreciate it, my presentation notwithstanding. If there's still concerns with the court, we will take them on as best we can, and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All rise.
You are muted.
All right, so I'll do a quick recap here. So after the break there, Bev's going to take a little 10-minute break. So again, just at the start of that, she's like, no need to thank me, just go ahead. He talks about the pause and the stopping of communications. Are there any further conversations? There was not one mention of pause in the quote from Mr. Brennan. So he's kind of going through what Brennan said, and he's kind of going line by line. The defendant provided the outline, which is not correct. Then he talks about this email from Evelyn, who is part of Jackson's group. And it's addressed to Hank, is the very first one, Mary Ellen, and then a bunch of other people. It says the Dropbox link contains ARRCA reciprocal discovery. Please let me know if you have any issues accessing the info. They received that at 6:30. The Commonwealth received that at 6:30 on a Thursday. I'm not sure which, maybe June, sometime in June of 2024. And then the name of the subject line is Karen Reed, ARRCA reciprocal discovery. And the judge asks, what's the date of that? Brennan says it's not dated. So this was the exchange that Brennan had with her back on the 18th, the week before this. Then he goes back to the outline, June 23rd email from Wolf. Mr. Wolf, judge refers to that as the script. So let's see, the outline itself is not dated, but the attachment, but is the attachment, so you can, so yeah, sure, the outline itself isn't dated, but it's in an attachment, so it's kind of hard to not say that it wasn't sent on the 23rd. The name of the document is Wolf_Qualls document. That's also the title of the email. Was this disclosed prior to testimony? Mr. Alessi says no. And then he talks about the Commonwealth adding commentary. That would be nice to have. They had it 4 months ago. And then, shh, don't tell me. You were told twice. So he's literally going line by line. I can't wait for Mr. Brennan's reply to this, because Alessi was pretty much ripping into him. He says that's not a very good way to cover up something when it says, let's see. Oh, okay, yeah. The Jackson's direct drew out the, don't tell him, let's see. Jackson, he wasn't hiding, he was drawing it out. And then the bill, so I didn't know any of this. You know about this because the defense affirmatively turns it over to Karen. That's not a very good way to cover something up. And he concludes with, he doesn't want this to continue. He wants both parties to take a deep breath so that the jury can make the best decision presented to them. If there are any concerns from the court, please let us know so we can take them on. So, yeah, I can't wait for Brennan's reply. I'm sure there's going to be snark. Krista Limited Edition. Alessi is an appellate lawyer and incredible. Hey, Birdie B, how are you? Hello again. Good to see you. Squeak cap. Yes, my squeak cap. Squeegee. Nice. Let's see. Any other, what are you guys talking about? Anything I need to go back here and look at? All right. Doesn't seem like I missed too much. Hey, Clips and Vixen, stopping by to say hello. Thank you for stopping by. Appreciate that. All right. We'll just move forward. Okay, let's get back to it.
Alessi, I am.
You are unmuted.
Be seated. Go to the back and sit.
All right. So before I hear from the Commonwealth, Mr. Alessi, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yanetti.
Yes,
as an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know and when.
No, what he said was entirely accurate.
Okay. Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No. I did long before I looked at that transcript.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we've referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature. The
invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information, and that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCCA experts. That was it.
Your Honor, if I could, this is...
No, hold on. Ms. Little, It was just thrown on you that you're responsible for all discovery. But the same question for you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARRCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay, so I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that, but it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing of materials that there was information that showed that ARCCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanches started is not enough. This isn't just about Rule 14. My effort with the ARCCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know. A voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time the pause moment on March 24th and then reinitiating on May 5th, where ARRCA is actually billing the defense for their works before the voir dire, there had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Alessi, what you should do, what the court should do, is go to the federal government and ask.
So just to be clear, I am not having ex-parte communications with anyone about this case. So I am totally rejecting your request that I do that, Mr. Alessi.
It wasn't a request, Your Honor.
You suggested that I call them.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARRCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. It doesn't help the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents were provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARRCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARRCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARRCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information, it is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial, and it is also that information when you compare it to the representations that have been made prior to trial by the defense that has import. And I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Yanetti. He's a fine attorney, an excellent attorney who I admire. But there is a responsibility so that there are not a number of pro hoc vice lawyers doing different things, and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alessi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal materials, and there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask co-counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
call over there, please. All right. If I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've heard.
May I have a moment to speak to counsel?
Sure.
Thank you, Your Honor.
I will need to call the United States Attorney's Office and get an answer from the court.
All right. I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARRCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26.
No, I know that, but what date?
June 5th, 2024. Right, discussing scheduling and voir dire hearings, the defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing I've got a report, he's got the report, that's it. I'm going to start asking questions on the report, that's it. He can cross on the report, so as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report, and those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number for the court.
That's okay.
This seems to directly contradict the theory that Attorney Alessi has been promoting today of the rules of the road. This does not suggest that ARCCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Alessi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts from ARCCA, including Mr. Klein. And when we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCCA, and this is June 10, 2024, trial transcript 28.
Hold on one second, let me grab that.
Okay. I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continued questioning, you were told, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yanetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, the voir dire hearing. The court asks, well, I thought...
What page? I've got the transcript. What page are you on? Do you know?
No, but I can...
If it's just your notes, that's okay.
I can pull it up, Your Honor. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71,
okay.
line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning when you walked into court, have you and I ever met face-to-face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARRCA are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions, voir dire, and a trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence or information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice date of July 12, 2024. It's addressed to...
Hold on one second, please. Okay.
It's addressed to Attorney Jackson. And the position that the defense takes, Attorney Alessi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert other than the defense. ARCA experts knew. Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, or they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because the U.S. Attorney's Office.
22nd, I think.
Sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses, apparently, was the defense themselves. And then before that June 10th hearing, where the representations were made, there was a June 9, 2024 phone call. Another participated in telephone call with Allen. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about their potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony, it is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of it being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track to the bill that they send within 1 month of the defense that gets paid, that Commonwealth and the court never knows about. Talk about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness, we have no writing, no email, no correspondence, nothing to support or put in context the conversation. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality, the representations made in court, we also At some point, we're going to address the Commonwealth's position of violations of 3.6, separate motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I'd suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARRCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARRCA was independent, they had their opinions, and they were exculpatory. ARRCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial, and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question's going to be, why? Why did they improve? Why did the
Particular page you'd like me to look at without.
If you look at the first page,
Yes.
if I can have a moment.
You don't have to read any of it. You just tell me what paragraph.
Yeah, I believe it's just the first paragraph that lays out their findings.
Thank you very much.
I'd actually particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page,
Okay.
which is signed by all 3 of the experts, Mr. Wolf, Mr. Rentschler, and Mr. Klein, says essentially the same thing.
Okay.
So we would be oblivious if we stood here and said that the relationship between the defense and the experts, there is no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARRCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARRCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations or communications the defense had with the ARCCA experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor has mentioned the sidebar.
Which one?
The most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right. Thank you. Mr. Alessi, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they had been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to provide him testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And in the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not.
Okay.
Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
Right, so you just told I paid for their time. That was not said, right?
That was not said, but I'm saying there's always some inference about what he said, that what was said, but that was his response, that was it. But it was the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCCA people. I will go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion way early on.
Who is Mr. Klein?
He was a 3rd ARCCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
Let me be clear on what I meant by retain. He didn't testify.
It's been a long day.
I'm trying to answer your question.
I know, and I realize that you just said something that you want to explain. Go ahead and explain what you just said.
So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that testimony is bias. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCCA witnesses, because we weren't talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Yanetti, that's who I meant.
Thank you for bringing that up, Your Honor. And that was just ARCCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe...
So where are we? Are we the June 10th, Mr. Yanetti?
Your Honor, June 10th, that's exactly right. That's exactly right, was June 10th. It's important, he stopped...
So it's page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true.
You read that earlier.
Right, but Mr. Brennan just mischaracterized it again because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions and follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said, Mr. Jackson, didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little. I said, Ms. Little, when you got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3a. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3a1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question. A whole different question from whether the attorneys are in compliance with 3.3a. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it, and I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant and their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brennan?
Very briefly.
Sure.
My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed late, right? On a Saturday or something?
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alessi, Attorney Yanetti, certificate of service by Attorney Little.
Is it signed by Ms. Little? It's not, right? It's maybe authored by, okay.
She did not sign it. It was signed by Attorney Jackson, Alessi, and Yanetti. And this is the defendant, Karen Reed's opposition to Commonwealth's motion to exclude employees of ARRCA LLC. And here's the representation they make. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant, Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARRCA LLC, namely Daniel Wolf, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense. It is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alessi no longer likes the word retained, but that retained word has import. The reason he said it. Their words, their motion, is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court.
What time?
9:30 in the morning.
Okay.
Could we possibly go there and then come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here. Jim, we have these all scheduled at 9?
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
You are muted.
Do you want this stuff?
Sure. Goodbye.
We're going to take a moment to pack up.
All right, that seems to be it. Sometimes we get a hot mic. So there's Lally standing up. I guess he is, he's pretty much bald. He's got a little bit of something, tuft of something on top of his head. There he comes. There he is with glasses. And there goes Lally. Lally gagging. All right, so that concludes February 18th and February 25th. So let me just go through. I'll go through what we. First, we got to show you Super Bowl. Oh, Super Bowl. Oh, it's a kitty, kitty, kitty. Hi. Where's your good girl? All right, good girl. So that's the little Super Bowl there. All right, so let's let me pull this down a little bit. Okay, so let's go through what we just heard. Let me see here. So when they came back from the break, Judge Cannone says, while our memory is fresh, Mr. Yanetti, as an officer of the court, is there anything you dispute? He says, what we said was entirely accurate. Mr. Jackson, same thing. He doesn't remember the sidebar. Oh, but Bev does. Bev does. Miss Little, anything you dispute? No, but would add, as soon as the court issued order of reciprocal discovery, I provided it. I did provide it. So then the Commonwealth continued. I'm sorry. Defense was done. Commonwealth comes in. So Brennan's like, Alessi ended his argument with the Sixth Amendment, but it's still continual violations. The defense in the first trial presented ARCCA as completely unbiased with no compensation. He doesn't want to preclude ARCCA. He said that 3 or 4 times. He doesn't want to preclude them. He just wants to get fair discovery. So there had to be communications that we don't know about. That's a huge assumption. Judge, to be clear, not having conversations with the Fed, Alessi says, if you wanted to call them. So the relationship was hidden from the Commonwealth and the jury. That's a big leap. He blames pro hoc vice lawyers. He's like, she has 3 of them. She's carrying 3 for possible plausible deniability. Judge didn't receive the protection order from the feds. Judge Bev says, call over there, please. It would help guide me through this. Brennan's more like, have we met before? No. Do you know the female? Am I right? Nope. So those were what that's what Jackson was asking the ARRCA. So he didn't know about the payments until recently. Let's see, May 1st, 2024, witnesses called, get expected. Okay, so he's saying that the defense had this list of May 1st, that the witnesses that they were going to call expected to get paid. ARRCA's opinions changed. That's the first time. Okay, there were 4 reports. Why did they improve over time? We need to hear more about that. Number 4 is the one that parameters were extended substantially. Definitely need to hear more about that. ARRCA is clearly trying to accommodate the defense. How much more is out there? He's got another TUI letter going out. We know about the potential bias, but we don't know the full scope of it. I mean, serious accusations he's throwing out there. We shouldn't have to fight for this info. We have no confidence we will receive the information we deserve. Oh my gosh. How about the video? I know you guys were saying the same thing. How about the video? How about give the defense the video? Well, but that it's okay to piecemeal it out, but so defense gets back up. ARRCA, let's see. Mr. Klein was the third ARRCA. Okay, so she asked who Mr. Klein was. He was the third ARRCA expert. Who was this 4th one? I'm not sure who the 4th one was. That's when Judge sighs and says it's been a long day. That's me sighing. She asked Miss Little during the break when you got. Oh yeah, Alessi asked Miss Little during the break when you got the order and had to turn over the discovery. Did it come to your mind that there were March emails? She says no, I don't recall them, and I know we had to turn over the discovery, so she found the emails. There has to be a misknowing of facts for it to be a violation. Brennan gets back up, arguments with the court has always been Rule 14. Verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So I pretty much ended it like that. So, what are you guys thinking? Curvio, love the recaps. Can't wait to see what part we watch next. Let's see. The next up is, we have March. Let me hold on a sec. Just hold on 1 minute. All right, I just had a conversation with our producer, and we're going to do March. Let's do March 4th. Let's do this one. Let's continue on. Let's go do March 4th.
All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court, and before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed. Can I please identify myself for the record?
Good morning, Mayor. Laura McLaughlin for the Commonwealth. Good morning, Mr. McLaughlin.
I'm ready for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Al Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Hill.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
And good morning, Your Honor. David Yanetti for Karen Reed.
Good morning, Mr. Yanetti. Good morning, Mr.
All right, so we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ARRCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, or Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under daughter grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes at the Canton Police Station video. So that's the order that makes sense to me to finish up what we already had scheduled last week before we hear anything else. So the questions that I have, before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yanetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Yanetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
So, each attorney is legally accountable for the actions and statements of the entire team. So, now the questions that I have, Mr. Alessi, that you said were welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you called it. Could you stand, please? Because I am going to address you.
Yes, I was going to go to the podium.
Sure, go ahead to the podium.
Thank you. I didn't want to stand when you were talking.
You could stand. All right, so the pause email, as you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. You will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. And then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARRCA and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
I am inferring, Your Honor. I do not know that as a fact.
Okay. So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024.
Why wasn't the record of payment produced at the same time?
Same time as what, Your Honor?
As the invoice.
And you're referring to the record of payment being?
Yes. Why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, on the weekend, February 16th. In the Commonwealth's opposition, defendant's opposition to the Commonwealth's motion to exclude employees of ARRCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARRCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your question. I learned that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned...
You don't have to
I'm sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to... So I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through, and when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARRCA, is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it. Is in order to violate 3.3A1, the attorney in question has to know with regard to the fact in issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But, Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis in construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3a from everything else in the world, which I agree completely with Your Honor.
All right. I'm not going to ask other counsel. All right. So let's move on to the next motion.
Your Honor, if I could, the tabs that I had, I've marked them as exhibits. I didn't do that last time.
The white book?
The white book, and I had it marked. Mr. Brennan has agreed to them going. May I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was exhibit 1, so I picked off on 2 and worked it out before. What would you like me to do with these, Your Honor?
You can hand them to the court officer who will hand them to the...
Well, there you are. Thank you. Thank you, Your Honor. Have you concluded what you...
Yes, but let's get this one.
Okay.
Yes, 229.
All right. So let's go on to your... Did the Commonwealth want to add anything?
No, thank you, Your Honor.
All right. So let's go on, and I don't have the gem. 499. So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I've read it. I read it 2 weeks ago when it came in, Mr. Alessi. I'll hear you on your motion.
Thank you, Your Honor. I'm just getting myself reoriented
Take
back to it. Thank you.
May it please the court.
The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements. So it's very clear that's the subject matter of his testimony. Your Honor stated, with regard to Dr. Rentschler, that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury, the key point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm, and yeah, you'd have to be a medical doctor to treat, but that's not what the issue is, so I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With regard to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical causes of injury, that if you're not a doctor, with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no documentation of that. But let's assume, hypothetically, it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study, he doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was, for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition, and I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound, and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them. To. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists, and even then the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in a defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion. It's a methodology. So, again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support. But he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained, they have to give a fair and accurate depiction, and you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My. Her she had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin, human skin, when there's any pressure, particularly with a bite. It moves, it dimples, it hits the muscles, etc., etc. He gave no account for the condition of the human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So, with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is, in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is now one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities, a Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines this thesis on page 18. One of the problems is the lack of standardization of methods in reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence, page 63. Classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so, on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's what it issued. He's not. He was a police officer for 22 years. And even then, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, etc., etc. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. and he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So I respectfully request that he be excluded. There's no need for a Daubert hearing. It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the decedent.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object, is he? Are you planning on bringing that in?
I wouldn't ask him to do that.
No, okay. All right, so I'm hearing one motion.
Yeah?
Yes.
Mr. Alessi tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had before this case. And so, in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. That was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Alessi's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive. Variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Alessi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor. There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he hasn't, I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the package? The exhibits that I have are attached to the Commonwealth's, the defendant's motion.
They have.
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Alessi argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not in this package.
I think that's attached here. I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it has not been provided in this package, so I can provide that to the court. So I'll supplement those two different items for the court's reference. In addition to his experience, he was Chief of Animal Care and Protective Services of the City of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate canine brain project. In 2023 to current, it's associated with Harvard University. Duties include the investigation and documentation of dog bite and related human fatalities. Also, Division Management Consultant for Animal Care and Protective Services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. And so when we compare, I'll refrain from getting into too much of a comparison, when we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that he has measured the distance of all of those teeth specifically. And then in his methodology, he outlines each group of lesions. Specifically, lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Alessi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case, he finds canine DNA. So he does look to alternative sources. And mindful, there was pig DNA found, so it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there is no animal DNA. And so while there are different methods, and some of the things that Attorney Alessi spoke about, dentition, deal with human biting, not dog biting, his methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
Okay. All right, Mr. Alessi, any follow-up?
I do, Your Honor. Thank you. The Commonwealth did not address in its presentation, you heard, one probative, legal, or factual point I made because they can't. Specifically, the Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it. But the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. It wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number two. Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now...
Hold on, so that's Exhibit 1?
Yes, exactly.
Just give me a minute. Just put him back again. All right, so what page?
Every page. The point is, there's now one footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay.
So he's got it in alphabetical order. Importantly, the page before, 1399, at the bottom is entitled References and Materials Consulted that may affect my opinions in this case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't, because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and, for whatever reason, immediately truncated it. I will just reference that book is not peer-reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Daubert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Daubert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard. But what is it that he is participating in Harvard in? And this was from the words of Mr. Brennan. Canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Dalbert Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Okay. Anything else, Mr. Brennan?
Briefly. On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr. Alessi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Alessi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter if somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
Okay. So before we move on to the next motion was, it was filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative, a Dalbert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Alessi, this is you again, right?
It is, Your Honor.
All right, so I'll hear you. And this is paper 515.
May it please the court, Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground. with regard to his qualifications, his qualifications to opine on the hardness of the ground. He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes. So his certified weather statement is hard as a rock, I believe. I'm looking for it.
So I'm sorry, there were a couple of exhibits attached to your affidavit, Mr. Alessi?
Yes.
All right, so one's Exhibit 1, I don't see any.
I'm sorry, Your Honor, it's Exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right. I don't see anything that says certified weather statement. It's an email, right?
No, his report is Exhibit. Well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable. But he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And, Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it. Because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using a layman, like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Thank you. Mr. Brennan, first question, do you intend to call this witness in your case in chief or for rebuttal?
I do. Case in chief.
All right, I'll hear you.
Thank you. The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed, to talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock, and state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Okay. Would you say that, Mr. Alessi?
Oh, you did, Mr. Brennan.
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic because, just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze-thaw effects on penetrometer resistance and shear strength of...
Why don't you put those in writing?
Was
that just a Google search? I saw that you had it on your...
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
I'd be pleased to provide a copy to the Commonwealth.
All right, so I'll take this under advisement. So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, or the cases and the qualifications of Dr. Crosby?
I can have that to you today.
Great, okay. And those articles, Mr. Alessi, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
Would you like me to hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Alessi? Did co-counsel have copies?
Oh, no, co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out something here that's...
Sure. You don't have to do it right now. Do it before you leave today.
I'll do it before I leave, Your Honor.
And that way there, we'll see to it. Jim, can we get a copy made for everybody? Thank you. All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. And this involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15-20 minute recess now. Does that make sense to everyone?
Sure.
Okay.
All right, to the board, please.
Is the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, I'm going to see counsel.
You may be seated. Quiet, please. Still on the record.
All right, just trying to find the breaks here. I'll do a little recap in a second. Let me just get us up to speed here. So they come back here. All right. All right, so this is from the March 4th hearing. I do have that properly pinned, right? Yes, okay. So Judge Cannone comes right out of the gate saying, I want to be very clear, Mr. Yanetti wasn't on the email. Ms. Little didn't know this. Mr. Jackson didn't know that. So when one of you speaks, you speak for the entire team. If you make representations, you make them for the entire team. Each attorney is accountable for the entire team. Then she reads the email of from Mr. Jackson to Mr. Wolf asking for the CVs. Wolf to Jackson, the U.S. District Attorney asked for us to pause. That's the pause email. Do you know for a fact there was no communication? Alessi says, I'm inferring, and I don't know that as a fact. So then Judge Bev talks about the invoice. It was paid July 25th. Why wasn't there a record of the payment produced at the same time? So Alessi says he learned that Sunday night about the February 18th, or he learned that Sunday before the February 18th hearing. So again, Bev's like, well, what one lawyer knows, all should know. Alessi says, well, he did the presentation in chronological order, so that's why, Judge, you found out in the middle of the trial, in the middle of my presentation. It says no attorney can be responsible for another's attorney misstatements of facts during the trial. I don't know if that satisfied Bev or not, but that's what he ended up saying. All right, so the first motion was a motion of the defense to exclude the expert testimony of Dr. James Crosby. So Alessi goes, the entire proposed testimony, because they want to kick out the entire proposed testimony because he plainly is not qualified. His methodology isn't reliable. It's not documented. And it's interesting that he's a law enforcement. He was, so anyway, we'll get to that. So they talk about biochemical engineers are not qualified to testify in medical terms. Crosby is neither a vet nor is he a forensic odontologist. Let's see, his expertise is canine aggression. That's the name of his company, and he's a certified canine consultant. So he's not a medical doctor. He can't opine on the causations of John's right arm or the wounds on John's right arm. So his methodology is he took measurements of John's arm and he took an imprint of Chloe, and there's no documentation that it was Chloe. So now all of a sudden he has access to Chloe. I didn't think we had access to Chloe, but apparently he had access to Chloe. So he takes those and he takes a photograph of John's arm. He takes Zoe's teeth imprints and he tries to make some kind of summation on that. He's measuring, and then he claims it was done by a sharp object. He provides zero evidence it was caused by a dog or a sharp object. He uses the hospital's wristband to use as the measuring stick. Oh my gosh. And then Dr. Russell talked about all these errors. The first was he treated John's arm like it was a static plastic mannequin arm. Of course, you're going to move, when you're being bit, you're going to move, you're going to react. Dr. Russell says arms move when attacked, and Crosby didn't take that into account. Never accounted for defensive movement in his methodology. Second was photos used. There was no documentation of who took them. One is blurry. Third is there was not one citation to support his findings. So the Commonwealth spent more words in attacking Dr. Russell than in supporting Crosby in their opposition. They spend more time attacking Dr. Russell than in supporting Crosby. That tells you a lot. He read Crosby's thesis that was cited in the report. In it, he talks about bite marks can generally be defined as a pattern. Remember, absolute probing of Dr. Russell on how patterns aren't real science. Well, now I guess it's okay. Crosby confirms Russell's methodology. Not one reference to methodology in his thesis. He thought, well, maybe in his PhD thesis, which the Commonwealth did not cite, but there's zero mention of his methodology in that. And that was from 2 years ago. What he does talk about is fatalities and dog attacks, and that was not the cause of John's death. Remember, the dog attack was not what caused John to die. Crosby agrees that where possible, medical examiners should document and try to determine which wounds were caused when, and defers to forensic pathologist. He was a police officer for 22 years. So is it any surprise that he was called? Of course, let's just keep it all in the family, right? And he wasn't even involved in the K-9 department. So it wasn't until after that he left that he became interested in dog behavior. He's not a medical doctor. He's not a vet. He's not a forensic odontologist. Your Honor, since it was a close call to allow Dr. Russell to testify, and she made sure to tell us, it was a close call. Crosby is as distant a call as possible. And then the judge asked, will Crosby testify that this injury was caused by some sharp object? He says no. She asks Brennan from the Commonwealth. He doesn't plan on calling Crosby in his case in chief. He will be on rebuttal, if anything. And basically, Brennan's his only leg to stand on was Crosby's testified in court. Russell has not. That's nothing to me. Defense got back up. Commonwealth didn't address any probative issues I brought up. what did Crosby actually testify to? Sure, he testified in some cases, but what did he actually testify to? Not once did Crosby testify that a wound to a human was from a dog. Let's see, Commonwealth comes back up. Court cases, he cites a couple court cases Dr. Crosby has testified to. Well, then he threw some serious shade. At least Dr. Russell wrote, at least Dr. Crosby wrote his report. So implying that Dr. Russell did not write her report. Any lawyer can craft a report. So I'm surprised defense didn't come back to that, but they didn't. So then now it's the defense motion to exclude Robert Gilman. He's a meteorologist, and he's attempting to opine on the soil hardness of the day in question. Meteorologists talk about weather, not that the ground will be hard as a rock. I don't know. I'm okay letting this guy in. Why wouldn't they want to have a meteorologist come in? Because he's going to talk about the temperature. He's going to talk about wind conditions. He's going to talk about snowfall. I do think we need to know how much snow was on the ground, because I think that came up a lot during the first trial. Was John covered? Why weren't there tracks in the snow if he allegedly was off in the basement and they dragged him out? Why, were there tracks? How much snow had fallen? When did it start to fall? I'm really interested in. I would love to know specifically when did the snow start? How much fell? And at like 6:30, how much snow was on the ground? Would it be enough to cover a body? Because there's multiple people that have gone by the location say there's absolutely no way that you would not see a body on the front of the Albert's front yard. So I would like to know how much snow fell, because when Karen and Jen and they were out looking, Karen immediately says, "Oh, there's John." So apparently he wasn't covered up. So how on earth did everybody else leaving that party and Lucky, the snowplow driver, how did they not see John laying on the ground? So I for one am really looking forward to that. The Commonwealth does not plan on calling Gilman. Oh, they do plan on calling Gilman in their case in chief. He's going to talk about temperature, wind conditions, snowfall, yada, yada, yada. They're going to ask about blizzard conditions, and thus will the ground freeze. And Bev asked Alessi, did he do a Google search on that? Then we're at the Commonwealth's motion to impose sanctions. So this one's going to be interesting. What kind of sanctions are they looking to impose? Inquiring minds want to know. What are you guys worried? What are you guys talking about? Oh, Zach, it's your birthday. Well, happy birthday, Zach. Happy birthday to you. I'm trying to find out where was the, let's see. Okay, so you're saying happy birthday to therapist you know. You turned 27 for the 22nd time. Yours was yesterday. Well, happy birthday to you, Zach. Hope you had a good one. Worst blizzard ever. Somewhere between 1 inch and 42 inches fell, depending on what point we're trying to prove. Yeah, totally. But then we need to know how thick John was so we know if the inches of snow was sufficient to cover him. Yeah, that I think you can kind of, I think you could probably say usually a body, let's see, usually a body is, 8 inches, 9 inches, 10 inches tops, 10 inches, right? Oops, I got two there. Yeah, so I would say 10 inches, so from where I am, my body to, it's like 8 inches. So I'll go another 2 inches. So 10 inches. So I would say it would have to be a foot of snow. And even then you'd probably see your feet, because your feet are like, 10 inches. So you would probably see your feet, So it was stellar. Oh, good to hear that, Zach. Glad you had a good one. All right, let us get back to the Commonwealth's motion to impose sanctions.
seated.
Great, I want to thank you both for getting me these materials, Mr. Alessi and Mr. Brennan. Thank you both. All right, so the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Rule Criminal Procedure 48. Mr. Alessi, do you need a minute? Did you need a minute? I saw you just...
Could I please just...
Sure.
Thank you.
Jimmy?
Yes, I'm working on something.
Why don't I take a 5 minutes?
All right, please.
Another recess. So let's get to... All right, let's get to some of your, this is really good stuff. All right, Curviel says Karen left him at 12:30. John wasn't out there. John wasn't out there until closer to 2 a.m. Only fan, he had no frostbite. He was not out there that long. Did he have a beer belly? Possibly. What was he wearing? It was winter. He only had like a jacket on. I think his other jacket, he only had like he had a shirt and then a sweatshirt, I think. I don't think he had his other shirt on. Crystal Limited Edition, y'all are not considering how long he was actually out on the snow. Yeah, so if he was out there before it started snowing, and if they got 10 inches of snow, would that be enough to cover him? Probably not all the way. I don't think not all the way. Mr. Alessi needed a minute or two, so I can fast forward, but she said they're only taking a 5-minute break, so I figured I'd check in with some of you guys. How much snow fell after 12:30? That's why we need the meteorologist. Seagate says he was out there long enough. Well, he died of exposure, so, right? Did he die of hypothermia as well as the brain? I thought that was his official cause of death, was hypothermia. Correct me if I'm wrong. I thought it was hypothermia, but I could be wrong. Let me look it up. What was, unless you guys know, I'm going to look it up. What was John O'Keefe's official cause? Do you guys know for sure? Blunt force trauma to the head and hypothermia. Okay, so his blunt force, medical examiner attributed his cause of death to blunt force trauma to the head and hypothermia. Right, so those were his causes of death. So he was out long enough to have frozen, right? Surely if there was wind could double the snow. It could double it or it could push it away. It could do both, right? We know his head was covered. What about the drifting with the snow? Yeah, it could. Okay, they're back, it seems like.
Hear you on this motion.
Thank you.
As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials were just some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, and given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watch other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information to the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of a jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court, it's unfair to the people of the Commonwealth, it's unfair to the Commonwealth, it's unfair to the prospective jurors. And so, not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We turned it over as a text message and notice of discovery 51. A protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements, and despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARRCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yanetti, and I have a clip of it. He also appeared on court TV with Ms. Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is...
Where was that court TV appearance?
I can get the date for Your Honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact. There should be a gag order on all of these attorneys. Every single one of them. And the Commonwealth will not speak either. Ms. Reed, I'm not asking for a gag order for. And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions, and that's what I'm asking for. Thank you.
Okay. Mr. Yanetti, you're arguing this, you said?
Yes, Your Honor. May we approach, please?
Okay.
Thank you, Your Honor. And may it please the Court. Your Honor, as I mentioned at Sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's protective order. That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him, and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate, and I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently revealed Social Security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order, but this communication got by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury minutes?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I didn't. I do have concerns about my ongoing obligations, so perhaps I could have a moment, Sidebar.
Sure. All right, Mr. Yanetti, go right ahead.
Thank you, Your Honor. And thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in...
We did that because that was material that needed to be done at sidebar.
Oh, I understand, Judge. Oh, no, and I'm
I just
thanking...
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the First Assistant U.S. Attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement, and what was the date that you all found out about what Mr. Brennan just announced in court?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe, perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. Okay. So just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Okay, thank you. Any follow-up, Mr. Brennan?
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yanetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist, it is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
If I may just briefly respond, Judge. I'd like the court to take particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response. So it's the motion to amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and the Commonwealth's opposition. I would like to hear that now. You need to give me a minute. The parties have any problem hearing that motion now? It is a
No, Your Honor, I think it's very brief.
All right, so I need 1 minute, Mr. Jackson.
Of course.
Can you write it to me again? The ones from this morning, the new ones? That would be fine. I have to check. All right, so you're both prepared to argue this motion, right? The motion and the opposition?
I'm so sorry.
So both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger because of...
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I speak with counsel? May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G-I-A-M, P-I-E-T-R-O, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sallyport videos and then about another 15 actual videos. I basically...
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Has anyone on the defense team looked at them?
I know Ms. Little was...
Your Honor, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves, dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sallyport garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something in connection with C, or is it blurred in?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30. Thank you.
All right, go ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the table.
So what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just want to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion to filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that I had.
I have not looked at them. Attorney Lally did, and he represented that they're all the videos we've already turned over, same quality as we previously provided.
Okay.
They're just copies of the same videos, although I do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting them, we've passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do, I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sallyport video and related evidence, that has to be filed by Thursday with the idea that we will have a hearing on this on Friday. Okay. We have Friday already blocked off. This way here, you can all leave for today, and we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Mr. Yanetti after 5:30 on night. So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
Of argument time, Your Honor?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Oh, of course. Yeah, yes, I believe we would, for sure.
How does that schedule work for people?
It works for the Commonwealth.
I need to ask this one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court. I want you to be able to just go do that and not have to come back here tomorrow afternoon.
Yeah.
And I'm trying to consolidate this now so you can leave in a half a day today rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
Your Honor, 11 o'clock would work. I think I can make my flight. By the time we get done, I can get to the airport. That's fine.
All right, so where do we stand on the motion for reconsideration? It sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that. Obviously, we gave notice that we were seeking the motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the CAMPD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need, I know this motion was just filed, how long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file a written response.
Okay.
We're going to need a couple of days.
Okay.
I think we have motions when they do Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if the court allows, because with all of these hearings, it's taken away quite a bit of our prep time.
All right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday, and I don't need to bring everybody back Monday.
We can do that now.
All right.
Your Honor, I would ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions in limine due on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss, though, right? You've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that in the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not change anything at all. I won't know until I have a chance to actually go through everything.
But I need time, right? I need to know by Thursday. Doesn't have to be a complete report, an outline even. Would the Commonwealth be satisfied with an outline? You know what the points are?
An outline of what you are.
Of what Ms. Little says, how this late disclosure of videos.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I want to supplement it very quickly thereafter. I have to decide this and put something in writing. So I need it to be done as quickly as possible. And you've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
May I have 1 minute, Ms. Little?
Your Honor, given what Ms. Lee just said and the court's concerns, I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow. I will concede
this. What?
The motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hang-up is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right. Ms. Little doesn't look thrilled.
Right. Her key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay. What's the Commonwealth's position?
I'll defer to the court. I know it's more complications with the defense and travel will be available in a
So I think we did block off today and tomorrow, with the understanding that the defense team would not be here until sometime 11 o'clock or later. What about, Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on Friday...
I just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back tomorrow evening. And Ms. Little will handle it's her motion anyway.
I greatly want to accommodate the defense as we have the entire time I've been here, but we have trial prep to do as well. In more court hearing days, we have hours of conversation, the more time we can meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
All right, so Ms. Little already filed the motion for me to reconsider. Why don't we hear that tomorrow as well?
Very well.
Okay, and then we'll just finish up everything tomorrow.
Very well.
All right. All right, and then you won't have to be here Friday, but the motions in limine are all filed. It also involves filling out a final trial conference report.
Understood.
So you need to do that as well. That all has to be done by Friday.
Understood.
And then, my goal was not to bring you back one day at all next week, because then we're going to have a full hearing. I believe it's the 18th, and the motions in limine.
That's right, the 18th.
All right, so you have a whole week next week to, you and I both, try and get everything done.
Should we file a formal motion to ask the court's permission for a delay from Friday till Monday?
For the...
Motions in limine.
The Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday? Were they all on Friday?
Reciprocal discoveries due Thursday. We want that to happen. Motions in limine, I believe, are due Friday.
Ms. Little, would you like the weekend for all those motions in limine?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you very much.
Motions in limine to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the Daubert motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for...
Dr. Wolf, it's a neurologist. So there's one additional...
I was thinking the ARCCA expert.
No, Your Honor. It's the neurologist of the Commonwealth. Wolf without an E. W-O-L-F. That was filed 2 weeks ago, I believe.
I have not seen that.
Okay. I'll make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their Lanigan motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right. If you get word that you'll be leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just contact the clerk's office.
Sure. Okay.
Anything else for today then?
Not for the defense, Your Honor. Thank you.
So I'm going to give you all a... why don't you fill up all the signs? I'll be out to touch.
Order court, all right, please. Session, you may be seated.
Okay. So where do we stand? If there was something you all were talking about, is there anything that concerns me?
Not at all, Your Honor. I think the schedule that the court had just articulated is the schedule that we'll follow. Mr. Brennan and I have discussed it briefly. The motion to dismiss, Ms. Little's motion, which I can't remember the name of it. The motion for reconsideration, thank you. And the Daubert-Wolf motion, I think we can try to compact all those in together.
So we will impact them.
Done.
All right,
Yes.
so Mr. Alessi, are you arguing the Daubert motion?
I'm arguing the Daubert motion, and I will compact it as Your Honor has just directed.
So let's finish all this tomorrow.
Understood. Thank you, Your Honor.
All right.
All right, so see you all tonight.
All rise to the court, please.
Of course, she comes in with a big meow, 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 but then as soon as we're here, you want to come say hello? Come say hello. Huh? Yeah, come say hello. Meow, meow. Meow, meow. Come say hello. Come say hello to your fan base. Meow, meow. Meow, meow. Meow. Come say hello. Come here. Meow, meow. Meow. Nope. Well, she was being all meowy. All right, so, okay, that was from March 4th. March 5th, it's getting a little late. It's 5 o'clock here on the East Coast, so we'll pick up on Wednesday. So tomorrow we're going to be doing Oscar Solis, who is the gang member that deleted the Uber Eats driver. He has got a hearing tomorrow. And then we're gonna switch gears and do Donna Adelson. Yeah, she is camera shy. So so basically they were talking about the motion to dismiss. They're gonna pick it up on March 5th. So that's really gonna be the big one. You gonna say hello? Hi. You say hello? Oh, kitty. There you go. You say hello? Say hello to the good people. You say hello? Meow, meow. Meow. Nope. All right. All right, guys. So with that, I want to say thank you to Aaron. Thank you to all of our fantastic mods. Thank you to chat. Thanks for being with us today. Join us tomorrow and Super Bowl. We will be covering Oscar Solis. That's going to be live. And then we're going to pick up on Donna Adelson and some hearings that we've missed of hers. And then Wednesday, we'll be back on Karen Reed. And then, Higgins. We got Higgins, that New Jersey versus Higgins. He's the drunk driver who hit the two National Hockey League players. So that's going to be Wednesday. So tomorrow is going to be live with Oscar Solis. We're hoping that they actually stream it. I think they will. And then some Donna Adelson. And then Wednesday, New Jersey versus Higgins. And then we'll pick back up on the Karen Reed. And we'll also probably do that Thursday because it looks like it's going to be quite a few hours of that. So anyway, thank you guys for watching. Thank you for being with us. Appreciate you all. Have a wonderful night. Super Bowl says goodbye. You going to say goodbye? She's going to lick herself. All right. See, Higgins did it. Yes. All right, guys. Have a great evening, and we will see you all tomorrow, 9 o'clock. I think the Oscar Solis starts. So, you say goodbye? Oh, got a lick. Meow meow meow. You say goodbye? Nope. All right, guys. We'll see you tomorrow. Have a good night.